Underhill and one part of Rexhaj and Secretary of State for the legal.
Yes, Miss Smythe. I ought to know by now whether it is Smythe or Smith, but it is Smythe, isn't it?
It is Smythe, my lord.
Yes.
Yes, thank you. My lord, yes, I appear on behalf of the Appellant Secretary of State. Mr. Metzer KC appears with Miss Safalahi and Miss Rakim Genova for the respondent, and for the Air Centre is Miss Nike KC, Miss Asanovic and Miss Durr. There are a number of housekeeping matters.
You can say that again.
Quite, yes. What order would the court like to take those in? I know that there's an outstanding.
Well, actually, I don't think there's probably all that much we need say. You wrote a very full apology for the state of the authorities bundles, and I've rather lost heart for kicking people off about the state of the other bundles. Only necessary to say that this case has not been properly prepared on either side, or any of the three sides, frankly, and it's made preparing for it extremely difficult, and much more difficult than it should have been. But I don't propose to say more than that. I hope lessons will be learnt by those involved. We have now the three bundles in folders marked 1, 2, 3. There is the one that has been helpfully handed up, which is now going to be called 4, which is really the material we were sent this morning. And we have 3 bundles of authorities. We also have some loose materials, perhaps they're not loose anymore, that have come in from the intervener.
Yes.
So I think we've got everything. We know where it is. We've got everything helpfully many times in several copies. But I don't think any more housekeeping is needed unless what I've just summarised seems to you to be not the complete picture.
My lord, no, that is absolutely correct. I will repeat my apologies, both my personal apologies and any apologies necessary on behalf of those instructing me in relation to the bundles. Those apologies are sincere. The second issue is that there are some bits and pieces to sort out. So in relation to timings, I've been asked to make clear to the court that Mr. Metzer and Miss Nike have prepared on the basis that I will go for this afternoon, and we anticipate, unless I'm particularly speedy, that that's how long it will take to show the court various bits and pieces.
Well, it may, but I think if we finish your bit at, say, 3:45, we will want to hear from Mr. Metzer.
Of course.
Yeah.
Yes. The second point is this, that the parties have been collaborating since last night on a chronology, which there were some final points on. We would hope, if the court would find that helpful, to hand that up in the morning or later tonight. It just brings everything together in one place.
Well, there's no harm in that. I'm bound to say, having prepared for the case, probably what all of us do at a fairly early stage is do a chronology for ourselves, working
Yes.
chronology. So I don't think there's any surprises there, but when you finish it, let us have it.
Yes, thank you, my lord. And then finally, the Air Centre would like the court to have a copy of the case of Sadiqa, which is a fairly recent judgment from this court in which I appeared for the Secretary of State, only because it sets out some of the background, although it's on a different issue about extended family members. So I think they will be referring to that as necessary in their submissions, but the court has it.
So if it's available now, let's have it now.
Thank you very much.
Yes, you were saying about timing. The position about timing is this. We will obviously certainly hear from you first. We will really only expect you to focus on the core substantive issue. If points are going to be made about the extent to which that's a departure from your position below, I'm not sure they really are, but if they are, they can be dealt with by Mr. Metzer in response, and you can deal with them in reply to that. So we'd really like to go straight to the substance of the matter. We would like to hear from the appellant and respondent all the way through on the issues raised by their skeleton arguments. We will then deal with the intervention separately, and that certainly will be tomorrow. I think it's only fair to warn Ms. Knight that at the moment we see very considerable force in the points made by you in your response to the intervention, although, well, sorry, not in response to the intervention, in response to, all right, in response to the intervention, not in response to the application to intervene. Frankly, if your points are right, they should have been made at an earlier stage to stop the intervention altogether, but we are where we are. We do see considerable force in those points. We will ask Ms. Knight first to start her submissions by saying why these points are in fact open to us in the light of the points that you make. But that's all for tomorrow. I just thought it was fair to Ms. Knight to warn her that she has a problem there.
Yes.
You may be able to overcome, but.
Do I take it from that then that your lordships don't want to hear me in relation to the submissions that the Air Centre have made at this stage? I've obviously dealt with them fully in writing. I was prepared to make some brief submissions, but I can skip that.
Yes, you are right in thinking that.
Thank you. But there is one final point, although it turns on what your lordship has just said, which is that there's an outstanding application for the Air Centre to rely on evidence. And again,
Yes, well, let's cross that bridge when we come to it. I think we really want the intervention and the issues raised by it to be dealt with separately at the end, if Ms. Knight persuades us that we ought to be dealing with them at all.
I'm very grateful. In that case, could I note, first of all, where the Secretary of State's written argument is, although I'm sure the court has it. It's in bundle 3. There is a replacement skeleton argument at page 72 of bundle 3. There is our response to the Air Centre at page 59 of the third bundle, and of course there is the further note sent this morning, which is also at the end of bundle 4 on page 26.
I wouldn't like to say anything whilst my lord is speaking, but although I've got many bundles, I'm not sure whether what I've got bears any relationship to what anybody else in this court has got or to you. I've got what looks like 2 core bundles until you read the index, and half the things in the second core bundle, which I thought was core bundle 2, are different from the one I'd worked from. Then I've got a third bundle, so I've got 2 core bundles. I've got a third bundle, which is an agreed supplementary bundle, and I've got a 4th bundle, which is the stuff that came this morning. So are there 2 versions of the core bundle?
Yes, there are, unfortunately, and this was picked up by my Lord Justice Underhill before the hearing. What happened was that the court prepared a bundle and then asked those instructing me to prepare a bundle, which was done, and that is bundles 1 and 2.
Right. You want me to work on bundle 2?
We've agreed between us that bundle 2 will be the bundle that we use for the main papers. I don't need to refer to anything in bundle 1.
So I should mark the bundle 1 because we read that first, but
I'm
it
so
doesn't
sorry,
matter.
my lord. It really is, I accept, entirely unsatisfactory, and lessons have been learned. Yes. So, with that then, could I just give the court a route map? Our headline point is that we say, despite the complexity of some of the background, this is actually a very short and simple point about construction of the immigration rules.
Yes.
Did the respondent need to show dependency or not? And that turns on, fundamentally, the meaning of this appendix.
Yep.
And we say, as a headline, she didn't have leave to remain under this appendix. What she had was entry clearance under a different appendix, which was converted into leave to enter at the border.
Yeah.
So the order of my submissions, I'll take things in 3 parts. First, to take a brief look at the facts. Second, to deal with the legal framework. And then third, to the extent that I've not already made my submissions in doing that, is to make submissions on our grounds of appeal.
Yeah.
So turning to the facts, our replacement skeleton argument gives hard copy page numbers, but just given that there have been further documents sent last night and provided in hard copy, could I take the court to the new bundle 4? And I'll explain explain when I'm explaining the law the difference between an Appendix EU application and an Appendix EU family permit application, but just to headline it now.
Sorry, I got confused. I thought you were doing the facts.
I am doing the facts, but to
It
make
sounds to me more like the legal framework.
it's simply to make the facts make sense.
Oh,
To
okay.
just navigate us. There are two applications made by this appellant.
Yes.
An Appendix EU family permit application
Yep.
and an Appendix EU application. And just as we're looking at it, the Appendix EU family permit application is an application for entry clearance. So
Yes.
that application is in the fourth bundle. The application is at tab 1 of that bundle, and the covering letter is at tab 2. And for completeness, just to show the court at tab 2, that the cover letter asserts that the respondent is dependent, and that is at the top of page 12.
Well, it doesn't use the word dependent, but the substance.
Yes, indeed.
But is that more than a debating point?
It's just for context. It was asserted in that letter. I did promise yesterday when I sent over the second application that I would say if any supporting material was sent with it. There was nothing sent with the second application to substantiate that assertion of dependence.
Sorry, this is the second application.
The-
But you're doing the this is the first application.
Yes,
This is the application for an entry clearance.
this
Yeah.
is the
The second
application.
one is an application for leave to remain.
Exactly, yes. So this first application is granted, and my Lord Justice Underhill asked, is there a letter which grants the application? The answer to that question is there is no such letter. What happens is the applicant will get a letter saying, can you attend in person and collect your passport?
This is at the embassy in Albania.
Yes, and then at tab 3, this is what is collected.
Yeah.
So, could the court look first at the top? It says, it's quite small writing, but it says valid from the 15th of November 2021.
First thing you want to look at surely is the big bold words entry clearance. At the
Good
very
point.
top.
Your Lordship makes a good point. Yes, it's entry clearance.
Yeah.
Yes. So entry clearance, and then it says valid from 15th of November 2021.
And the significance of that is simply that's the date that she turns up at the embassy, is it?
No.
No, it's the date. So the date from which her entry clearance is valid is the 15th of November
Yes, but
2021.
why that date when she applied in June?
Because that's the date from which she is allowed. She has
Yes, I know,
entry
but
clearance.
what's the difference of that? I
It's
just assumed.
Is that the date of grant?
the date of the decision. Yes, it's just
Yes, but does the decision consist in the putting of this into her passport?
Yes.
So effectively, that is what I meant.
Yes,
Yeah.
I'm so sorry. Yes,
Yeah.
exactly. So valid from the 15th of November 21, valid until the 15th of May 2022, and then it says type EU settlement scheme family permit, which is a form of entry clearance. And
So
then-
family permit, which is a phrase I haven't seen in any other context. It's just another way of saying what might otherwise have been called visa or entry clearance.
Yes, it's a special name that's used in the EU and the withdrawal agreement context.
Yes.
And sorry to be obsessive, but I read the 4 letters above that, which is MULT, which I took to be multiple.
Yes,
And that made me think, how then is that connected to the immigration order? But you'll come to that, because if it's an immigration order conversion, that's one entry, not multiple.
yes,
But you'll come to that.
I'll turn my back and ask for an answer to that question from the experts, if I may. Yes.
But can I, if I make a note saying the term family permit is a special term derived from the withdrawal agreement terminology.
It's not derived from the withdrawal agreement terminology. It's terminology that the UK used in the EU context
I see.
domestically, and also uses in the withdrawal agreement context, but your lordship.
I
will
see. It
find
goes back to the days when we were still in the
It does,
EU,
yes.
and in circumstances where you needed something in your passport, you normally wouldn't have, but with free movement. But the terminology derives from what I might call EU terminology.
Some people did need entry
Yeah.
clearance, and or they might want entry clearance,
Yeah.
and the name for that under the EU system was the EEA family permit.
Yeah, that's fine.
Under the yes.
No problem. I just wanted to. It's important in any judgment we write to use terminology correctly.
Yes, indeed.
And the full expression EU settlement scheme family permit
Yes.
derives from FP1 in the Appendix EU family permit.
It does, my lord. Yes,
An entry clearance in the form of an EU settlement scheme.
indeed. Yes. So and the court can also see that the respondent entered on the 25th of
Just
December.
before we get there, it also says to join. I mean, that's odd bit of to join what? To join whom? That's just
to
clumsy,
join
is it?
the name have a Rexhaj.
No, that's her name.
Oh yes, I'm so sorry.
That also-
Empedincia at the
Yes.
bottom. It's her daughter-in-law, I assume.
Yes, exactly. Oh, I hadn't noticed that
Yeah,
name
so
appears
it's-
at the bottom. So we should.
Yes.
It's just a question of layout. Really, there
Yes.
should be a link between to join LM credit. Yeah.
Yes,
What I assumed.
Yes. No, that makes sense.
yes.
Yeah. Thank
So
you.
what we then have at tab 4 is the application under Appendix EU. That's tab 4, page 14 of that new bundle 4. What I should say, I'm not proposing to go to that form, but I should say that it's an online form, and what we've provided is what is fed through to the Secretary of State's casework system, which is why it appears in that format.
Yeah.
And as I mentioned earlier, I checked what was uploaded with it, and the answer is nothing to do with dependency. Now, apart from my note at tab 5, which the court
Is there
may
anything
have
we should look at in this form?
not from the Secretary of State's perspective.
It's almost all no's, isn't it? The only one that on page 16, based on your relationship to someone eligible for the EU settlement scheme, then the name of the family. Yes, I see. Thank you.
Now, apart from my note at the end of this bundle, which the court may have separately, I'm not going to go back to this bundle.
No, okay, thank you.
Now, what the court has also been shown by the respondent is some correspondence from the appellant solicitor dated the 4th of April 2022, and that appears in bundle 2 in the hard copy at page 89.
Yes, I think as it happens, all of us using hard copies, so you needn't bother to give
Thank you.
soft copy references.
My lords, we do have clearer versions of those pages in hard copy, if that ever sits, because they're quite hard to read.
Well, that's very nice of you. Well, all right, we got them. Will you hand them up? Thank you. Clearer, you mean bigger?
Bigger, yes.
Are they hole punched? No, okay, don't worry. Thanks. I'll
Now, all that I
well,
want
hang
to
on. Oh, I see. All right.
all that I
Well,
want-
I've asked for them, but I think actually I'm going to use the one in the bundle. That's not illegible. Yes. So
essentially, this is a letter asserting that the applicant isn't required to evidence dependency, and I need only show the court that under the EUSS.
yes.
But I ought to explain to the court that this followed a letter from the Home Office asking for evidence of dependency. And what this court may not be used to in the immigration context is the Secretary of State saying, hold on, you haven't provided us with this, and giving somebody an opportunity to provide evidence. That happens in the context of the EU settlement scheme because of the arrangements that the Secretary of State made under the withdrawal.
He made a point of the statement of intent as was going to be helpful instead of not that the Home Office is ever unhelpful, but
So that's what happens. That's what leads
yes,
to
I
this
see. Have we got
letter.
that letter? We don't really need it.
I did get hard copies. I didn't want to trouble the court with any more paper. I've sent them to my learned friends, and I have them. in
But
court
basically,
if the
they
court-
just say in response to a letter which says what?
The
No,
letter
you
says-
haven't provided evidence of
You haven't
dependency.
provided evidence of dependency. Have you got?
What's the date of that letter?
We don't know because it's undated
Oh,
on
I
our
see, okay.
system. What I can say, and what is dated on our system, is that when the Home Office gets the letter I've just shown the court, the Home Office does reply on the 5th of April saying, actually, you do need to show dependency for the very reason that we are making this appeal, because you haven't been granted leave under Appendix EU. So the Home Office does reply to that letter
On the next day.
on the next day. Things
Things are wonderful under the EUSS.
they are indeed, except as perhaps it concerns bundles. So
Very well, but so let's just see what this letter says. It says on their part you're not required to provide evidence of financial dependency, and they they make various points which are like the points they're going to be making later.
And where's your letter saying, no, you're wrong?
it's not. No, it's not
Oh,
there.
okay, don't worry then.
I can
If
hand it up.
if it's not substantive, I think you're right. We've got enough paper. If it's identity substantive, we'd want to see it. It just says you are required to show
It says you are required, and it says why. Effectively, it says because you've not been granted leave under Appendix EU, which is the very thing that the Secretary of State's saying now.
Well, I suppose. Have you got several?
I do.
I think for form's sake, we better have it.
Yes, I do, and I have.
Tell the story
I
in the
have
judgment.
provided this to the
Yes.
other council.
Well, it doesn't sound as though it's just, as it were, so we got the whole story.
So it doesn't have a date on it because it's an electronic letter, but it's the 5th of April. that
It's
it's
not
sent.
illegal to put a date on an electronic letter, actually. The Home Office may discover
Thank
it
you.
often helps.
It certainly
That's
does
very
after
nice.
the event,
Don't worry,
yes.
don't worry, we've done it now.
You don't probably type them all the time, and I put the date in myself.
Yes, it is odd. I mean, I thought this programme could be set up that as easy as pie, that put the date on printouts from electronic things. But
Yes, I don't know the answer to that.
there's some
although-
rueful smiles from behind you. No doubt it will happen.
Yes, things often not as easy as they appear to be.
No, well,
Perhaps.
that's also true.
So what this says is thank you for your letter sent in response to our request that you provide us with evidence of your client's dependency. As you have mentioned in that letter, a requirement is now in force for applications submitted on or after 1st of July 2021 to provide evidence of their dependency.
Yeah,
I-
we're going to hear all these arguments,
You are.
so I don't see any point in you.
Yes,
I just thought we'd better, for form's sake,
Yes.
have the letter. Thank
yes.
you.
Could I then ask the court to turn to page 84 in bundle 2, which is the Secretary of State's refusal decision.
Yeah.
The way that these decisions work is that the Secretary of State first deals with whether somebody qualifies for settled status and then deals with whether they qualify for pre-settled status, which is indefinite leave and limited leave respectively. So first of all, just below the hole punch on page 84, it says, third paragraph, unfortunately, based on the information and evidence available and the reasons set out in this letter, you do not meet the requirements. There's then, from the bottom of page 84, to
If she had met the requirements, she would in fact have got pre-settled status.
yes, that's right, yes.
You only get settled or indefinitely to leave should have 5 years.
Yes,
Yeah, so and she could apply for that once she had been here for 5 years.
yes, that's right.
Exactly.
So, first of all, bottom of page 84 to almost the bottom of page 85 is the consideration of settled status, but so that the court sees it, in between the two hole punches on page 85, further consideration has been given as to whether you qualify as the joining family member of a relevant
Which is
sponsor.
in fact all she's ever asked for.
Yes, which
And this is, well, again, I don't make a fuss, but this is the way the Home Office does things. It has a single template that covers everything, whether or not everything is relevant to the particular case.
the way that the rules are set up is that a person will only be eligible for limited leave if they're not eligible for indefinite leave, and that I imagine, and I'll turn my back, is because the scheme was designed to give people the best thing that they could get.
Yes.
So that's considered even if somebody hasn't asked
Yeah.
for
Well,
it.
I'm not, don't want to give anyone a hard time about it, but possibly for good reason. The first part of this is irrelevant.
Although the rule is the same for settled status as it is for pre-settled status in relation to dependency, and that's why I'm showing the court that passage which begins further consideration has been given as to whether you qualify as the joining family member. As you have applied on or after the 1st of July, evidence of your dependency must be provided.
Yeah.
And then that's repeated in relation to pre-settled status, but that doesn't repeat the reasoning that I've just shown the court. And then
Hang on a second. I see. So wait a moment. Yes, pre-settled. In fact, formally, the only relevant bit is the last starts with the penultimate paragraph on page 85. Careful consideration has been given as to whether you meet the eligibility requirements, and it says you don't. But part of, and it says it very shortly, it finishes 5 lines down on page 86, but that in practice incorporates what has been said above.
exactly.
Yeah.
And then the court will see underneath, again, different to normal immigration context. We attempted to contact you numerous times by email, telephone, between 4th and 5th of April to ask for the evidence specified above, but this has not been provided. So
Yes,
the Home
we've
Office,
seen at least once.
Yes,
You've already
indeed.
told us about it.
and then just for completeness, bottom hole punch page 86, there's a reference to appeal rights, and I'll show the court the legal source of that statement. And then bottom of page 87, it's always open to somebody, if the deadline hasn't passed, to make a new application under the EU settlement scheme, and those applications are free of charge.
Yeah.
So, going to the second part of my submissions, which is the law, and again, just to give the court a route map, I'm proposing to take things in this order, which is broadly chronological. First, to start with, and out of the chronology, is to just show the court the scope of the appeal right in this appeal. Second, then, in chronological order, is to show the court the directive only because the withdrawal agreement applies one of the provisions in the directive.
That's the one that includes the dependency requirement.
Yes. Third, I will deal briefly with the history of the withdrawal agreement and development of the EU settlement scheme, which is covered in the note I sent this morning.
Yeah.
Fourth, I'll look at the provisions of the withdrawal agreement that are relevant. And then finally, I will show the court the detailed rules both for the EU settlement scheme and EUSS family permit in the 2 appendices.
Very well. Some of those you can take very shortly.
Yes, exactly. So, turning first to appeal rights, authorities bundle at 7, page 138. I don't know if any of your lordships are working electronically. If not, I will
No,
use
we're not. Which page did you say?
So it's tab 7,
Yeah.
starting with regulation 3 on page 139.
There's no. Is there any point taken on this?
It's only relevant in terms of is the air centre intervention relevant? Is the air centre intervention within the scope of this appeal? I'm happy to move on, but I didn't know if the
Well,
court
now
would
we're
want
here,
to
let's
see.
just look at it, yeah.
Yeah, so regulation 3(1)(c) is the right of appeal. So it's a decision not to grant any leave to enter or remain in response to P's relevant application, which here is the application under the EU settlement scheme, which was refused. The right of appeal is against.
Sorry, say it again. Here is the what?
So here,
Yeah.
the right of appeal is against the April 22 refusal that I've shown the court,
Yeah.
which is a refusal of leave under the EU settlement scheme.
Well, you say under the
Remain.
EU
Leave to
settlement
remain.
scheme, but the EU settlement scheme is a phrase that comprises both the FP and the Appendix EU, doesn't it?
It does. It does and it doesn't. The Home Office talks very specifically about the EU settlement scheme to mean Appendix EU.
Well, that
And-
it may, but I've seen some passages where they're treated as parts of the same thing.
Yes, and they are both part of the EU settlement scheme, but they're discrete in the sense.
Oh, they're
that-
certainly discrete,
Yes.
but I'm not being picky. I just want to get this conceptually in my head. It's quite important. The EU settlement scheme, we haven't yet seen, maybe you're going to show us, any legislative reference to such a thing. There's lots of policy references to it. But whether we're talking legislatively or in policy terms, the EU settlement scheme comprises both the Appendix EU rules and the Appendix EU FP rules, doesn't it?
No, it doesn't. So the EU settlement scheme is Appendix EU, which is leave to enter or remain.
So the EU settlement scheme is only Appendix EU.
Yes, if it's entry clearance, it's EU settlement scheme family permit.
And this is because the key word is settlement. Because under the FP, all you're getting is entry clearance, which
Yes.
is nothing about settlement.
So-
Whereas the EU covers settlement and pre-settlement, which is itself leads to settlement.
Exactly.
Is that
It is,
is
and
that why you're saying what you're saying?
It is, yes, and it may be.
Will we
that-
see that articulated anywhere in any document? It makes sense, but I'd just like to.
Yes. Could I come back to your lordship
Yes, of
on that
course.
point, if I may?
Article 18 of the withdrawal agreement says that member states may have a new scheme for resident status after withdrawal. Some didn't, some, including the United Kingdom, did.
Yes.
So the likelihood is that that which constitutes the settlement scheme is that which is meant to replicate the Article 18 thing. There may be additional things to do with the way that we do things, like having entry clearance, which may or may not be part of it.
Yes.
Okay.
Yes. The other point, of course, is that the Home Office could have given EU settlement scheme family permit a different name, which didn't use EU settlement scheme at all. But that's
But it did. Well, that's an
did.
example of the
Yes.
blurring.
Yes,
I understand your
but that's-
conceptual point, but it's not actually always observed in practice.
indeed, yes, and,
Okay.
and that your lordship is quite right to ask the question. And then the ground of appeal is on page 141. The first ground is that the decision breaches any right which the appellant has by virtue of, and then there are various references there to the withdrawal agreement. That's not,
Sorry. Yes. Yep.
and then the second ground of appeal, and it's the ground of appeal which was pursued here, is that the decision is not in accordance with the provision of the immigration rules by virtue of which it was made.
Wouldn't you expect there to be a pretty well total overlap between the two types of grounds, because the immigration rules are designed to reflect the withdrawal agreement?
No, because in a number of respects, they're actually more generous than the
Yes,
withdrawal
well, I was
agreement.
about to say, in one respect at least, it was for a while more generous because it's assumed dependency.
Yes, although there's a
There are
a
other
much
respects in well.
bigger generosity than that, in the sense that under the withdrawal agreement, any EU citizen to fall within scope needed to be exercising a right to reside in accordance with EU law.
Yes,
The
I
UK
see.
decided instead that it would require residence only, and that's
Simply
what it
continuous
tests.
residence.
Does
Yes.
not test compliance with EU law.
Oh, well, that's okay. That's interesting. But that's why, although there will be some overlap between
Indeed.
the two grounds, but not an identity.
Yes, because somebody
Okay.
might want to say you haven't properly implemented my rights,
Yeah.
and indeed have done in cases which have reached this court, and then that's a withdrawal agreement ground.
Okay.
So turning then back to tab 2, this is the directive which was the main instrument in relation to citizens' rights before the end of the transition period. Could I just invite...
So which tab are we on
We're
now?
in tab 2.
Yep.
I need really only show the court Article 2, which begins on page 35. This is the definition section.
Hang on 1 second. Sorry. Yep.
So Article 2 definitions begins at the bottom of page 35, and there's a definition of family member at the top of page 36. The key provision here is D. Family member means the dependent direct relatives in the ascending line.
Under Article 2.2, a non-dependent mother would not have a right under Article 2.2. There may be other rights
Yes,
for facilitation, but EU law always required proof of dependence.
it did. Yes, and actually the extended family member provision also required dependents. So there was always a requirement for dependents. So you can be, as a direct family member, which is what this covered, you can either be dependent on your own child or on your child's spouse or partner, but you have to be dependent.
Yeah. Instead, I think you said 35. It's actually 36.
Sorry, page 36 is where the definition is. Yes, starts on page 35.
Thank you.
Now, if the court wanted to know what dependency requires as a matter of EU law, I don't need to take the court there now, but for the court to note, at tab 18 of the authorities bundle, there's a case called Lim, and that sets out the relevant EU jurisprudence, and paragraph 21 to 25 of that case explain what the dependency requirement needs. It's paragraph 24 which sets out a citation from an ECJ case. It's not an issue in this case, but in case the court were curious, that's where it is.
Thank you.
So the next part of my submissions was to deal with the history of the withdrawal agreement and the EU settlement scheme. And the court has my note. I'm not going to repeat that in
Well,
detail.
I think we would like to be taken through it.
Yes,
I see. Yeah.
I'm certainly going to highlight some of the key points in it.
Yes.
So, starting then with the development of the EU settlement scheme. So this is now this note is in bundle 4. If the court doesn't have it separately at tab
Well, it's
5.
useful to have it in. I'll use it in that version. Yes.
So essentially what happens after the referendum is that the UK begins to work on the position of EU citizens living in the UK, and that's what this note described. So in June 2017, the government publishes a document which is called Safeguarding the Position of EU Citizens Living in the UK and UK nationals living in the EU. And that is basically, and the court doesn't have it and I think doesn't need it, but that is basically the basis of the UK's negotiating position
Yes.
in relation to what becomes the withdrawal agreement. So that the UK publishes that paper and another paper, and then negotiations on what becomes the withdrawal agreement then begin and continue. And then in March 2018, a draft text of the withdrawal agreement on citizens' rights is published. So that's covered in paragraphs 5 and 6 of my note. What then happens 3 months later in June is that the Secretary of State publishes the Statement of Intent. Now, this has been relied on by the intervener. We've included some extracts at tab 25 of the authorities bundle. Could I, perhaps, because it's helpful in setting things in context, just show the court some passages from that?
Yes.
So tab 25.
I find it a very well drafted document, or at least the bits we saw.
So what it has, first of all, on page 727 to 728 is a forward by the Home Secretary.
Yeah.
And then there's a summary.
Paragraph 2 is interesting. I'm delighted to be publishing further details of how the scheme will work and how simple and straightforward it will be for EU citizens and their families to secure status.
Yes,
Well,
Optimistic.
there may be a distinction between the drafting of the appendices, which you will not be surprised to hear the members of the court have in this and other cases found dauntingly difficult.
yes.
But the way the scheme has operated in practice, where I'm sure your instructions are worth, I have heard, most people have found it very easy to operate.
Yes,
We see the cases which are on the margins.
yes, and I was junior in Akinsanya where your lordship expressed those points, and certainly that's accepted. I think that the point probably to make on behalf of the Home Office is that there are a lot of situations to cater for, and it's quite difficult coming up with something in the rules which isn't complex. It's acknowledged that they're complex. What I will say is that the Home Office has certainly developed a lot of guidance and done
Yes.
a huge amount of
Well,
work.
I think we probably, the courts in, I'd forgotten it was Akinsanya, but I think
Yes.
not only in Akinsanya have made
Indeed,
disobliging
yes.
comments about the drafting. We're not writing an essay about it again this
Yes,
time.
fine.
I'm sure there's something to be said for the defence, but it's not something we have to decide.
Indeed. I'll move on. So could I then ask the court to look at the summary on page 729? So just by that top hole punch, in line with the draft withdrawal agreement with the European Union published in March, the EU settlement scheme will mean that. And then could I ask the court to look at the fourth bullet?
Yes.
Because what the court will see is that refers to dependent parents.
Yeah. Yes.
And then in the introduction section, again, that is repeated. So at paragraph 1.6, it says, in line with the draft withdrawal agreement, this is at page 730, the EU settlement scheme set out in the statement of intent. And then at the fourth bullet, it says close family members. And again, it says dependent parent or grandparent
Yes.
living overseas will still be able to join, etc., etc.
Yes. Yes.
What it also says at paragraph 1.11, and perhaps unsurprisingly, is the rest of this document sets out how the government intends that the scheme will work in practice and includes a draft of the rules. But then it says, just above the top hole punch, the immigration rules for the scheme which are laid before Parliament in due course may differ from the approach set out in the document, in
Yes.
the draft rules which it contains. And of course, it's well established as a matter of law in this court that there's no expectation that immigration rules won't change. That's the Turkish business people case. But in any event, that the document says that, unsurprisingly perhaps. And then chapter 2...
Which case did you say was
It's the
Olada
Turkish-
Hindi?
No, there's a specific case called Turkish business people where there was an argument. I think it was a legitimate expectation.
Well, no, I mean,
case.
you're right. It's trite law. I just associate it with a different case.
No, your lordship is right. Turkish business people was quite specific in that it was about whether or not it essentially says that unless there's a specific promise, as I recall, that the rules won't change.
Yeah.
rules can change.
As I say, the label I put that on is Olada Hindi, but
Yes, and all of
I may
those-
well be wrong.
No, your lordship is quite right, because it's all of those cases also which say you apply the immigration rules as at the date of the decision. Yes.
Yeah.
So just I'm not going to spend a long time in this document, but given that it had been relied on and perhaps by the respondent building on the Air Centre submissions, I wanted to give the court a full picture. So
Yeah.
paragraphs 2.4 on 736 is a reference specifically to family members resident overseas on the 31st of December 2020, and the court will see there a reference to close family members, which is referring back
Yeah.
to what was said previously. And
Well,
then,
it was also in the footnote, isn't it?
yes, it's in the footnote, exactly. It says dependent child or grandchild or dependent parent or grandparent.
Yep.
And then we've just extracted chapter 6, which was the section relied on by the Air Centre. So 6.5 says, otherwise, this is what family members will be eligible for the scheme. Blah, 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 and then it comes on to people who aren't EU citizens in paragraph 6.5. Otherwise, the following family members of an EU citizen who is continuously resident here by 31st of December 2020 will be able to apply for status. So that's not joining family members. And that refers in a bullet just below the first hole punch to the child or dependent parent. And then at 6.6, it refers to detailed criteria which will apply.
Sorry, I've got lost.
So it's
What's the 6.2? 6.1 deals with those who are there on implementation data and is irrelevant. 6.2 then deals with joining close
yes.
family members, and is everything that follows glossing or giving details about people joining family
No,
members?
it's not. It's the specific section. So 6.4 is it's talking about both, as I understand it.
Oh, is it? Right. Hang
So-
on one second. Just sorry. Yes, all right. Well, we ought to know talking, or perhaps you did and I didn't mark it, but 6.2 again, just making the same point you've made several times already. You talked about
Dependents.
close family members, again, footnoted as including dependent parents. Yeah. So,
And then 6.3, the rest of this section provides more information about who these family members will be. So that's all family members. And then 6.4 is looking at where the applicant is an EU citizen who's resident here by 31st of December.
Yes, I see, sorry,
2020. So
yes.
that's not this case.
yeah.
And then 6.5 are dealing with family members of an EU citizen who is themselves continuously
Yes, I see.
resident here by the 31st of December. Either where they're already here
Yeah.
or where they join after 31st of December 2020, so it's covering both. That bullet then under, it's the third bullet, refers to the child or dependent parent.
Yes.
So that there is a requirement for dependency in substance, but what 6.6 essentially says, 6.6 says the following detailed criteria will apply in respect of each of these categories of family member at the date the person applies under the scheme. And then on page 740, in the middle of the two hole punches, dependent parent, what it says is, at the very last two lines, the dependence of the direct relative in the ascending line on the EU citizen or on their spouse or civil partner is assumed. So at this early point, there is a substantive requirement of dependency, but it's assumed in practice that it's met.
Ah, yes, I hadn't spotted that in my pre-reading.
That's
So, contrary to what I'd understood, from as early as the statement of intent, the intention was, although it had a dependency requirement, that was effectively deemed to be satisfied in the case of a parent.
yes.
And that's always been an element of the.
At this point, and that's essentially how it is.
Thank you. Yes.
For any family member, and has continued for any family member who is resident in the UK at the end of the transition period.
Just remind me, how do you know it's only those who are resident at the end of the implementation period?
Not from this document, but at this point, there are no rules about joining family members because they're not. It's too early for that. They're not.
But at 740, is that limited? Is the assumption limited to those who are resident?
As I read it, given what 6.5 says, it's not limited.
No, it could
No.
apply to
Yes, it could.
joiners from abroad.
Yes,
Yeah.
exactly. Yes,
Without limit of time as to when they,
yes.
after the end
But-
of the
but it-
transition period, they apply.
At this point, the draft rules don't cover that situation because it's too early for that.
Well, you say joint rules. I mean, these are not joint. These aren't joint rules, are they?
Sorry, at this point,
Sorry, but
yes.
I'm being difficult. I just want to be clear. There was a set of rules annexed to this statement of intent. We
Yes.
haven't got those.
Yes,
These are a summary or an explanation of what is in the rules.
yes, but
And if we would therefore really wanted to bottom this out, we'd have to check what was in the rules.
yes, but they say
this is clear enough.
yes, because at this stage, this is just the EU settlement scheme. So in relation to your lordship's question earlier about are they the same thing, they're not, because at this point, these rules are only for people who are resident here until the end of the transition period.
Is that right? I thought the end of
Although-
6.5 was suggesting that if you are not resident here, but join after the 31st of December.
Yes, that's what this text says. But in terms of the actual immigration rules, and I'll show the court the actual rules. There aren't any rules for family members joining after the end of the transition
There's a mismatch.
period.
There's a mismatch
Until-
between what the statement of intent says and what the annexed rules say.
Yes, because at this point it's too early for the joining family member rules, and they're not developed until that statement of changes.
When you
is
say that,
seen.
maybe you're right, but if I was only reading this document, I
Indeed.
would get the impression that the position had been thought out for joining family members as well as for family members already resident here.
Yes, that's fair in terms of the text, but the position in terms of so this, of course, is an
Have
exploratory.
we got the rules that were annexed to this?
We can provide those. What I've done in the note is essentially say what the rules said from once they actually came into force.
All right, I'm
from
sorry.
the 30th of March.
Well, that's a
which is
perfectly
the
sensible
same.
thing to do, but I'm sure it's my fault. You were taking us to the position at the time of the statement of intent when there are no rules, there are only draft rules.
Yes.
We haven't got those, and you haven't told us what's in them, except orally just now. You've started to tell us what's in them.
Yes, I think it. I was concerned not to provide the court with unnecessary information. We can certainly do that, but
Well, let's see how the argument goes.
Yes.
But can I summarise where if we were just looking at this statement of intent, unless I've misunderstood it, it appears to say that the rules which it is intended to make, statement of intent, will assume dependency in the case of a parent joining from abroad after implementation date.
yes,
Right.
which although the-
Well, my lord isn't so
Sorry,
sure.
that's how I first read it, but I hadn't taken account of the words in parenthesis in 6.5, except for dependent relatives, who are carved out of those
yes,
who
that
are going to,
Oh,
as late joiners, who are going to be entitled, and dependent relatives, according to footnote 17, are those who are defined in paragraph 6.6, which is what we've just been looking at
yes,
in
although
relation to dependent parents.
That-
I
that-
don't find that at all clear.
No.
I think it's complex because dependent relatives is a form of extended family member, which this court isn't concerned with. I hope
Well, let's. You ought to be able to demonstrate that.
Oh, it's actually, sorry, you're quite right. At 740, dependent relative
underneath.
is a different defined term
Yes.
from
Right.
dependent parent.
So once
Right,
you helpfully
sorry, as
clarified,
we were.
once you helpfully clarified that, then I think what I was putting to you is correct. For dependent parents, reading 6.5 and the bullet point we were looking at in 6 point, I'll start again, in 6.6, dependency was intended to be assumed for direct parents, for parents joining from abroad, both before and after implementation date.
Yes, as in fact happened, but
Yes.
only for a limited period.
I know.
Only for the 6 months.
Exactly.
Yes.
Yeah.
When I show the court, hopefully, the explanatory memorandum to what was HC 813, which made the rules for joining family members for the first time,
Yeah,
that will make sense of
absolutely.
the fact there were no rules for joining family members before then. But I can of course give the
The safest thing is surely just to take it chronologically.
Yes.
So the first document we've got, statement of intent, does not suggest that there will be that the assumption of dependency will be temporary.
No.
It is simply says it will be assumed, full stop.
Yes.
But that's only a statement of intent, and it makes clear that things may mature.
Precisely
Right. Well, so where do we go next?
So if the court could then look at my notes under relevant chronology of the immigration rules,
Yep.
position from 30th of March 2019 until the end of the transition period. So
Yes.
what happens before the 30th of March 2019 is that there are test phases
Yep.
of the EU settlement scheme. Now, there's no issue about joining family members at this point because EU law still applies, so people can come and go as they always had done.
Well, that's not simple. I mean, a dependent relative, actually, I thought, under the EEA Regulations 2016, would have had to prove dependency, wouldn't they?
Dependent parent.
A dependent
A
parent.
dependent parent, yes.
So until the rules come in, the EU law and the domestic law required proof of dependency.
They did, although because this scheme is more generous, some people chose to apply.
Not to apply for an EEA family permit, they could have applied for this once it came in.
Yes,
Yeah.
exactly. Although at this point, there are no rules for joining family members. So anybody, as your lordship says, the rules were stricter under EU law. So anybody that wanted to come as a joining family member as such needs to comply with the EU rules, unless for some reason they benefit from the EU settlement scheme.
But presumably, they will. Anyone who did. Well, almost by definition, when anyone who could have applied under, you were saying, well, they could have applied under the old rule because the transition period hadn't yet expired. But anyone who did that could equally have applied under the Appendix EU,
Yes.
and therefore, if well advised, would have done because it didn't have a dependency requirement. It may even be the Home Office told them, look, you've made the wrong kind of application, you're just setting a hurdle you needn't jump.
For this particular category of family members, the law is clear that there was no need to make an application at all because EU residence rights were declaratory. In other words, if you meet the
Oh, I
substantive
see.
conditions, you have the right. It was only for a different category of family members that my Lord Justice Lewis is familiar with from the Chellick case, who did need to make an application.
Yes,
but for
I
a
see.
direct. So if somebody, as a matter of substance, shows they are dependent, then they have residence rights in the UK. They don't.
But how did that work? How did that work? Because, I mean, if you didn't have to make an application, you just turn up at the airport and show your French passport.
I'm so sorry, can I-
Non-EU, non-EEA people do have to show dependency. French and German ones are fine. It's the non-EU ones that have to.
Yes, they had to show they absolutely had to show dependency, but the point is they didn't have to apply for a document as such. So if they
I
turned
suppose
up,
you
National
were okay.
could just come in, but somebody from Albania couldn't come in. They'd have to show something, and they'd have to show that they were the mother of a
So-
daughter-in-law who was.
yes, your lordship's quite right. So because they would then be a visa national, they would need an EEA family permit, so
Yeah.
entry clearance. if they were here for some other reason, say, and you know perhaps they'd come in some other position and then became a dependent family member, they would have the right simply by virtue of meeting the conditions. But your lordship's quite right. Yes, for that category, they would need an EEA family permit.
Okay, but we're at risk, it's all helpful to get clear in our minds, but we're at risk of diverting from the main point. So when, with effect from 30th of March, which
Yeah,
is
so
the
that-
start of the implementation period,
No, the 30th of March 2019 is the date that the EU settlement scheme and the EU settlement scheme family permit are formally introduced through the immigration
yes, but am I
laws.
not right in saying that date was chosen because the implementation period was chosen as starting on 30th of March and ending on the 31st of December?
No, that began in January 2020.
Did it? Okay, well, I'm obviously wrong. I've made a note to myself.
Yes, it's exit day,
Yeah.
January 2020, and then the end of the transition period, sometimes called the implementation period, is the 31st of December
Yes, I see.
2020.
Okay. So this has no particular significance other than it is the date chosen.
That's the date chosen.
Yeah, I'll
Yes.
cross that out of my notes.
So at this point, we have the two appendices, Appendix EU and Appendix EU family permit. Now, what is, the court may wonder, there were no rules for joining family members at this permit. What is Appendix EU family permit for at this stage?
Yes.
Its function is to allow family members resident in the UK.
Don't take this at dictation speed.
Yes. So at this point, all that it does, Appendix EU family permit, is allow family members resident in the UK
Okay, hang on. UK, yes.
before the end of the transition period,
When you say transition periods, then you mean the implementation period.
yes, or
Yeah,
implementation
use
period,
the same
December
language, yep.
2020. It allows them to return to the UK if they didn't have entry clearance or leave to enter. So to help those, the category that my Lord Justice Lewis mentioned just now, they could
Hang on,
use
if they didn't have
entry clearance
entry clearance.
or leave to enter. So that's all that Appendix EU family permit is doing, but it's still
So
just about entry clearance.
it's my fault. I haven't understood it. So it's to allow family members who were previously resident in the UK before the end of the transition period
Yes.
and who've subsequently left.
Yes, they can return.
Sorry, yes, you said resident in the UK. You meant previously resident. It's a key word. Before the end of UK,
who have
but
left.
who have left.
I'm so sorry, can I turn my back for a
Yes.
moment? I have the expert behind me. Yes. So because of what I said about the EU settlement scheme not requiring the exercise of EU rights, the reason that somebody might want to apply under EUSS family permit is because their sponsor might not be exercising any kind of qualifying activity, but they could nonetheless get themselves back
Well,
into
this is a
the
completely
UK.
different explanation from the one you've just given. Isn't it?
No, I
Oh,
don't,
sorry.
I don't
Try one more time.
So
Well, perhaps we can state what the problem is. You're always going to have an Appendix EU,
yes,
and an Appendix EU allows dependent or assumed dependent family members to join.
no, who are here.
Well, no, because it also provides for leave to enter.
In some unusual circumstances, yes, it does. But by and large, it is about people who are here.
It
So-
doesn't matter that by and large it's for people who are here. The fact that it has within it, and it's quite important to your argument, the fact that it has within it the dealing with leave to enter as well as leave to remain means it is not simply about continued residence of those resident in the United Kingdom.
No, but in what circumstances can somebody apply for leave to enter under Appendix EU? That is addressed in paragraph 22 of our skeleton
I know,
argument.
but I find it very difficult to understand. You can talk us through it.
Can I mean, I ought to say, the background is all very complicated, and that is the difficulty with this case. The background is complicated, the issue is not, and it's the background, because there are so many different situations catered for, the background is immensely complicated.
Well, I know it is, but the whole purpose of an appeal to the Court of Appeal, where it's immensely complicated, is to set out as simply as possible, but it may be complicated,
Yes,
what it is. And then once you've understood the background, you may well be right. It all comes down to looking at the words.
Indeed.
But looking at the words in a vacuum is not very helpful.
no, I accept that, but I wonder if I wonder if this will make more sense when the court has the full picture, including HC 813, which introduces the rules.
All right, we'll do it whichever way you want. See, so you've got a difficult task, and if it suits you better to do it that way round, we'll stop asking you questions about this now. Can we just park that at the moment, I at least, but I think my lords as well,
Yes.
don't really understand the separate roles of the FP and vanilla EU
Yes.
appendices, or why it was necessary to have separate roles. Of course, we understand one is about entry clearance and one is about, broadly speaking, about settlement or leave to remain. And then we understand, of course, those are different things. Why you have to have different schemes for both, why aren't they all dealt with in a single appendix, isn't so clear, and nor is it clear why, if that is the distinction, there are sometimes references to leave to enter in the EU one.
Yes.
Now, there may well be answers to all of this, but at the moment, as you can tell, we're struggling with them.
And I completely, me too, to get to grips with it, so I completely understand. So perhaps could I start? I think it would be helpful to turn up our original appeal skeleton at this point,
Yes, sir.
which the court has at bundle 3, page 59, as I recall. Now, while the court is turning those pages up, turning up my skeleton, the reason why it's in two appendices is that it's a policy choice that has been made, effectively.
At what point, sorry?
A policy choice to
Because of the different ones, I'm really sorry
I'm
about
so
this, Miss
sorry.
Mike. I can't find a page 59 at the moment that remotely resembles yours.
72, bundle 372.
bundle 3, page 59, but I can hand up if it's easier.
No, I don't want another one. I've got one that I marked, one that I haven't marked. And the last thing I want is a third one.
No,
I'm
I
bound to
can
say,
imagine.
at 59, I've got Secretary of State response to the
Oh,
intervener's
I'm so sorry. I'm so sorry. Page 72.
Ah, right, okay.
So, this sets out the detail.
I'm afraid I
I-
just haven't got the document at all. You're going to have to give me yet another document. I'm so sorry, but it's impossible. It's a complicated subject, and having it in this fashion, Miss Mike, is making something that I'm familiar with impenetrable. If you have another document, I'll take the other document.
I can imagine, my lord. I can only apologise. I'm so sorry that bundle 3 has not reached your lordship, but this is my replacement skeleton.
This is actually the skeleton you've always had.
Yes, I think
It's just
so.
been
but I-
referred to in a different place.
Yes, and where I'm now told it is, it doesn't seem to be where I'm now told it is. So where I was looking at it when I did the preparation, did the marking, appears to be quite different, but I've got it now.
Your lordship may then, and
Don't worry, you've given it to me, don't waste time. Let's start with Division 3.
all that is the replacement version of what your lordship will have marked. So, paragraph 20, first of all, sets out that the two schemes. So if your lordship has been looking at my main skeleton, which is the appeal skeleton, this is simply the replacement version of it.
Yeah.
So paragraph 20 explains that the EU settlement scheme family permit and the EU settlement scheme are implemented through two separate appendices. So Appendix EU family permit is all about entry clearance. It's only ever been about entry clearance. And that's why it's kept separate, because it's about entry clearance. Now, what that says, and I can explain this in more detail, is that is for people who either are not eligible to apply for leave to enter under Appendix EU, or for some reason do not wish to apply for leave to enter under Appendix EU. And I'll explain that in more detail in a moment.
Sorry, can I just write that down? Who are not eligible to apply under Appendix EU.
For leave to enter.
So that's what you say in yourself, not able, but able and eligible mean the same thing.
Yes.
Not eligible to apply under Appendix EU for leave to enter, although they are eligible to apply for leave to remain under Appendix EU, or not?
No, that they won't be. So take this respondent to explain the position. She was
No,
not.
sorry. I just want to get the submission. You've said Appendix EU FP is for those who are not eligible to apply under Appendix EU for leave to enter. And do you mean not eligible to apply for leave to enter or leave to remain?
Yes, correct.
Okay.
Yes.
Or who do not wish to do so?
Yes. So that
Sorry,
is.
I just wanted to write it down.
Yes, I'm so sorry, my lord. I misunderstood the question. So that is this respondent. So such a person has to get themselves to the UK so that they can make an application under Appendix EU or another application under a different part of the immigration rules if they wish to. So they need this entry clearance to get themselves to the UK. So that's what Appendix FP does.
Is that right? Because I thought, well, certainly in its final form, EU 9, and I don't know whether that was in the earlier version, provides for a distinction between in-country and out-of-country applications, but it does allow out-of-country applications in certain circumstances if you have a specified relevant document.
Exactly, yes. And
One
that,
of which is a family permit issued pursuant to Appendix EU FP. Have I got that wrong?
yes, but it's...
Which would suggest, if I can just finish the point, that at least one of the purposes of granting the family permit under Appendix EU FP was to allow an out-of-country, not to allow an out-of-country application for those who are eligible to apply for leave to enter and or leave to remain under Appendix EU.
I may be misunderstanding your lordship's point. The difficulty is that those who are eligible to apply for leave to enter under Appendix EU are those who have what's called the required proof of entitlement to apply from outside the UK.
Yes.
And that would be a person who holds a specified relevant document,
Yes.
and
Yes.
that would include a biometric residence card.
Or a family permit.
Or a family permit.
Yes, but could I just turn my back for a moment?
Should we?
So ordinarily, that will be somebody who's already got themselves a document under the system that the UK had in place when EU law was in force. It's a document
But,
issue.
I'm not sure
but
that's
there
right. Can we
that
look-
couldn't be right.
Should
because-
we look at the provisions? Because I know it's tiresome for you, but this is
Not
what's
at all.
what's troubling me, and I just.
Yes.
So if we look at EU 9, which I've got at page 184
Yes.
of the authority bundle.
So this is Appendix EU.
Appendix EU.
Yes.
EU 9, these are the requirements for a valid application. A required application process, B applies where the application is made within the UK, and then C, the required proof of entitlement to apply from outside the UK has been provided where the application is made outside the UK.
Yes,
And then if we go to the definition of required proof of entitlement,
which is on page 247.
247,
A valid specified relevant document.
under B, in the case of a non-EA citizen, their valid specified relevant document. And then that takes us back, I think, to 224, doesn't it?
So
Well,
it starts at 223, but
Starts
the
at-
key relevant document is little 4 on 224.
yes.
No, it's a specified relevant document, which is on page 249.
Now, I'm getting, they're valid specified relevant documents, so,
So in B, the
Yep.
valid specified relevant document, there is a specific definition of specified relevant document on page 249. And that is very specifically a residence card, permanent residence card or derivative residence card issued under the EEA regulations.
So I was looking at just relevant document. That's why I've got that wrong.
Right.
Thank you.
It's completely understandable. I'm sorry that I'm not able to chart the course through it in any clearer or more coherent way.
I
It's
said I wouldn't
very-
give everyone a hard time. I mean, for a layperson or even a lawyer who's not steeped in this, to realise that specified document and relevant specified document are completely different concepts is
And yes, yes.
source for confusion. Anyway, there we are.
Does
So
that
that's
answer
what
the
you say.
question? So that is why those who can apply for leave to enter under Appendix EU is a very limited class, explained in paragraph 22 of our skeleton argument.
Can we just go back to 20?
Yes,
Now what you say, 20.1, the family permit. This sets out the rules for a person to be granted entry clearance in the form of family permit. Yep. So that they can enter the UK. Does that mean with the purpose that? I know, it's your skeleton, it's not drafting. What I mean is that's all it's for. It's not one consequence of which is, that is the purpose.
yes, but I mean, it's a way for them to get here. When they got here, they might choose to apply under a different provision of the immigration rules, but it's a special route for.
Well, that's quite an important point, isn't it? I mean, they might come here and then decide they want to apply as a student.
You could.
So why is it described as EUSS family permit?
Well, in fact, it could have been given a different name, but the point is it's connected to the UK's arrangements in connection with, before the end of the transition period, EU law, and then exit.
Okay, I'm just writing down. So you can get to the UK from where?
Sometimes somebody, sometimes somebody just comes for a visit, uses it to come for a visit, and doesn't want to apply for anything else. But it gets somebody here because of what I'll explain about. You get your entry period.
Well, hang on. Someone come. So suppose you want to come because you want to see the Tower of London.
Yep.
And well, it used to be a tourist visa, and you're from Albania, from which you would normally require a visa, but not one you'd have to apply for in advance. If you were a tourist, you live from Albania, you just turn up and present your passport.
Quite a lot of people now need entry clearance.
Yes,
Actually.
I see.
Yes.
Okay.
Can I ask two things? So is the purpose then of the EU appendix, in effect, to translate the rights of residence that you had under the EEA regulation, which in turn came from the EU treaty, that just converts them. So that's why you don't have a family permit as a relevant document. It's the thing that gave you legal status or confirmed your legal status under EU law, and it's just Article 18 turning it into the final system.
Yes, that I think is a good way of summarising what's very complicated. But does so more generously in some respects. It's basically bringing people within the immigration rules, allowing them to apply for leave to remain fundamentally, although given if that's why that provision about specified relevant document is fixed on people who had something already under the old system, because they can just get leave to enter under Appendix EU. That's why they've got that special dispensation. But what the system also does, as it always did, is enable people in the EU or withdrawal agreement context to apply for entry clearance.
To switch from the old rules to the new rules. The next question then, which is the trick question, because of 233 little a3, a biometric residence card issued by virtue of having been granted limited to leave to enter under this appendix, there still seems to be circumstances where you made an application and got a biometric residence card under this appendix, quite separately from having got something under the old EEA regulation.
Is your lordship looking at page 233,
233, yes.
of which is in the definition of relevant sponsor?
No, I'm looking at relevant documents.
So that relevant document is on page
223.
223. I heard 233.
223. And this is the other thing. You can either have, for your specified relevant document, an EEA permit, or you can have a biometric residence card as described in the entry at page 223. And that presupposes that you've somehow got something when you've been granted limited leave to enter under the EU appendix. So you must be able somehow to get leave to enter under the EU appendix, even if it wasn't what I and my Lord Justice Popplewell thought it was.
But this is relevant document is for extended family members. So it's dealing with that situation where the withdrawal agreement says, if you want to benefit from this withdrawal agreement, you need to have made an application under the domestic scheme by the end of December 2020. So this is catering for that particular class. So they may have one of these documents. They may have an EU settlement scheme family permit granted under Appendix EU family permit, because it also caters to extended family members. But that's what this relevant document is doing. It hasn't got anything to do with direct family members.
Okay.
Yes.
That works, but gosh, it's impenetrable. I looked at that and I thought it was the key, like my Lord Justice Popplewell, but I don't know it's specified. But
Yes.
Right.
I accept it's complicated. There is a lot of guidance out there which has been described in another case in one context as helpful guidance by a president of the upper tribunal, but
But not available to us,
we
unfortunately.
accept it's no, your lordships have to make do with me, unfortunately. I'm not doing a very good job at the
well,
moment.
the law is the rules actually. You shouldn't have to, and under the rule of law, you're meant to look at the rules and know what your rights are. You're not meant to have to go to something that isn't the law and take the.
So you're saying there is some guidance. Why, if the president of the upper tribunal has said it's useful?
Not in this scenario, in a different case.
I see
My
that
Lord
there is
Justice,
no
there is-
relevant guidance that addresses this question.
There is lots of guidance, and it would certainly deal with many scenarios.
Yeah,
that
but there's
come
no
up.
guidance that addresses this question.
In terms of which question?
The question of, well, I suppose ultimately the question of the circumstances in which dependency will be assumed.
There is guidance about that, yes.
And but that is consistent with your analysis,
Yes, it is.
and therefore you, in a sense, that's pulling yourself up by your own bootstraps, is that?
Yes, we haven't provided guidance.
Yes,
because-
okay.
yeah, yes.
Okay, well, it
So-
looks as though you have, by persistence, and don't do yourself down, Ms. Mann, you're doing very well in the circumstances, given what you have to deal with. You looked as though you have persuaded, my lord, that we should only be looking at specified relevant document at 249,
Yes. So
and therefore we are back in the situation in which the kind of person who is applying for under Appendix EU won't have applying from abroad won't have a family permit, is that right?
it's that it's basically backing up what I've said in paragraphs 20 to 22, which is some people, but only that limited class that I've shown by reference to specified relevant document can apply for leave to enter under Appendix EU, but unless they are in that specific class, and that's the class of people who have some sort of document under the 2016 regulations, they will need to apply for entry clearance under Appendix EU family permit.
And why are they treated differently? I mean, they have got a biometric residence card or another form of residence card under the UTIAC regulations.
So
What's special about them?
they've already, if they were somebody resident here before the end of the transition period, they will already have been in the UK and applied to the Secretary of State and had a document to recognise.
But that will show who they are. It won't show anything about their dependents,
Well, they would have needed to have been dependent to get it in the first place.
would they? I see. I haven't followed up the references in a Little Roman 1 AA or a Little Roman 3, but those will incorporate dependency, will they?
If your lordship means the definition of specified relevant document, yes, because that was a requirement, as my Lord Justice Lewis pointed out earlier, that was a requirement under the 2016 regulations. That scheme was not more generous than EU law.
Yes, I see. It's beginning to come together.
At some stage, one of us is going to ask you then about FP2, which seems to be the critical.
Well, I'm going to pull rank on my lord. Let's not do that now until we've been through the history.
Yes, it's perhaps. I mean, it's perhaps a useful point at which to say.
Unless you want to, it's another matter.
It's a useful point perhaps at which to say that, as I said earlier, somebody may just apply under Appendix EU family permit, get their leave to enter for the balance of the relevant period, and then go home again.
Yes.
Some may decide, right, I'm here now, okay, now I'm here, I can actually apply under Appendix EU, that's what I'll do. Or they may think, for some reason, no, I'd like to apply under Appendix FM or a different appendix as a student. That's just any form of entry clearance gets somebody. It's your permission in advance to enter the UK, just as the name says. It's entry clearance, so you're cleared to enter. At the border, it's converted into leave to enter for the balance, and I'm going to take the court to this.
Yes,
in
well,
my
we've
law
all looked
section.
at that, but I agree you better take us to it again.
Yes, so that's how it works. So although the appendix has effect in connection with the granting of entry clearance for the purpose of acquiring leave to enter or remain, it means it gets you here so that you can make the application because you'll then be eligible, but it doesn't make it the same thing. To headline my answer to that.
It's an oddity, but I think that if it's not only confined to people who are then going to apply under Appendix EU, it's called the EUSS family or permit scheme.
Yes, and it
But you just say that is an oddity.
could have been given a different name, but fundamentally that's the class of person that it's aimed at.
But the family permit that you get, there are, as I understand what you've submitted, there are no circumstances in which a family permit will be used for the purposes of getting leave to enter under Appendix EU. Because the family permit
Yes.
will be something that is evidence of eligibility, Section 33 of the Immigration Act, the rules, 25A, converted into leave. So when FP2, I know my Lord doesn't want to go into this, talks about getting a family permit for the purpose of requiring leave to enter by virtue of Appendix EU, that's basically meaningless because you've just told us that the EU family permit never gets you leave to enter under EU, as I've understood it.
That is an excellent question. I'm going to.
All right, well, such is a good question. I won't stop you answering it.
I'm not. I need to ask those instructing me why FP2 refers to leave to enter, if I may.
Sorry, this will sound catty, which I don't mean to be at all. Surely it's been clear ever since the decision of the upper tribunal. That's a fundamental question in the case.
Well,
We were
well,
slightly
no.
puzzled. There's nothing in your otherwise very helpful skeleton that addresses Appendix FP2, paragraph FP2 of,
Yes.
of the appendix, on which the upper tribunal based its entire reasoning.
Well, because we say that it's merely a purpose clause, and one has to actually look at the content of the rules. And
Well,
this-
yes, but you have to look at the content of the rule in the context of the purpose of the legislation, and here is the definitive statement of the purpose.
yes, I can't answer now why it refers to leave to enter, but the point is, if one just for the sake of my argument replaces that with the word status under Appendix EU, it's simply a way of getting yourself into the country so that you can make the application. But it doesn't convert one appendix into the other appendix because they have two very discrete functions.
Well, all right, but we will need a developed submission on Appendix
Yes, of
FP2.
course.
You may say it's just wrong, in which case
Yes,
we'll have to...
I will answer that point. I will answer that point. Just in terms of the chronology, I just wanted a bookmark for the court, and this is when we went into specified relevant document and so on. But where I was in the chronology,
Yes, no, let's step back to that.
it was on the 30th of March 2019 that statement of changes HC 1919 was laid before Parliament, and that introduced the EU settlement scheme in Appendix EU. This is paragraph 11 of my note, and the EUSS family permit in Appendix EU family permit. And the point I was making, which led to the various questions, was that what Appendix EU family permit was doing at this point was allowing family members resident in the UK before the end of the transition period to return if they needed entry clearance. So what it isn't doing at this point, because it's not a thing, it doesn't exist yet, is dealing with joining family members, because joining family members means people who come after the end of the transition period. So I'll explain that as we
I
go
see.
through. But
Hang on 1 second. Well, it's not addressed to joining family members in the sense in which that becomes a defined term at a later stage. In ordinary parlance, it is addressed
Yes.
precisely to ordinary family members, to
Ordinary-
joining family members,
Yes.
but not in that particular sense.
joining has it's a term of art in the withdrawal agreement which uses the word join, and that's why the Secretary of State refers to joining family members. It is, but I agree. If
So you
somebody-
said that the concept of joining family members only has effect post implementation date, post
as a
actual
concept,
withdrawal.
yes,
These are returners.
yes,
Be a better
returners,
word.
yes, they're returners, exactly.
The rejoicing rejoiners, yes. The
Yes.
returners.
They're returners, yes,
They know
They've
they
already
were
been
around the
here.
airport already.
yes. They've already been here. So that takes us to the 30th of March 2019, and your Lordship asked me, well, was that date of any significance in terms of our international agreement? No,
Yes.
it wasn't. But the next point in the chronology.
Sorry, I'm just getting another ink. Give me 1 second. Yeah.
So dealing with things chronologically, the next point in the chronology is the final withdrawal agreement, which, as we say in our notes, is agreed on the, I'm so sorry, I've lost my page, on the 17th of October 2019. Now, what I haven't troubled the court with at this point is what the rules looked like on the 30th of March 2019, but the court has that in my note at paragraph 12 and 13. So what we then get is the withdrawal agreement.
So in fact, so all of that says from 30th of March 2019, strictly speaking, this is as from the 17th of October 2019. Is that what you're saying?
No, it's not. The EU settlement scheme is introduced before the withdrawal agreement is finally agreed,
Yes.
which the UK is permitted to do under the withdrawal agreement. And I was just saying to the court that what did the rules look like on the 30th of March 2019?
Yeah.
That is set out in paragraph 12.
Yes, now, but doesn't that leave out EU 14A?
It does, because it hasn't, because those rules aren't made until later.
So for what purpose was the definition of, to which relevant provision of the Annex EU were these definitions that you've set out here?
The people already here.
But what is that? Which
So
paragraph?
They are the provisions in Appendix EU.
Yes, but
Um,
EU 14?
EU 11 and EU 14.
Yes,
So
it's the definition of dependent parent.
EU 14 I see, and EU 11.
equivalent for indefinitely.
Yeah, okay. Yeah, got it, thank you.
So that's where we are in the chronology, and then we have the agreed.
So if, at this point, if we were to look at the entire, we wouldn't find EU 14A. You're going to tell us when that comes in,
Yes,
okay?
from the end of the transition period, EU 14A.
From 11 o'clock on the 31st of December 2019,
Yes,
2020.
2020.
And is that in the statement of changes you're going to show us?
That specifically is not in that statement of changes.
Well,
no, but
I'm sorry, I was hoping to get a complete narrative. This is the rule on which everything depends, EU 14A. If you're telling me, I'll take it from you, but I wouldn't mind seeing the statement of changes in which it's introduced.
EU 14A.
Yeah.
Yes. It is H. I'm so sorry. I'm so sorry. My client is apologising, and I apologise. We misunderstood one another. It is HC 813.
I see, well, that makes sense, yes.
Yes.
Which we have got, or at any rate, we've got the intro to.
What we did is not give the court the entirety of HC 813, but HC8, we gave the court the explanatory memorandum, and the
Yeah.
changes made by HC8.
Is that where we're going now anyway?
Are reflected in the rules that the court had.
I don't want to take you ahead unless you were, but is that where you're coming anyway?
I'm in the court's hand. I was, because it's chronologically next going to take the court to the withdrawal agreement, but if the court would prefer, I can show the court HC 813 and the rules.
You do whatever you want, but if you're going to take us to the withdrawal agreement, I'd just like to know why it's actually relevant.
Well,
No real dispute about its effect, is there? There's some points to be taken on it by the intervener, but that of a different character.
yes.
But it's not relevant to any of the questions of construction before us, or am I missing something?
No, it's not. It's not. What I can say, I mean, it is very much the points that the intervener has made. I can say that it defines family members to be those persons who are family members under the directive. They need to be
Yes.
dependent. So, if the court would prefer, I can.
I
read
think in
the
that case,
withdrawal agreement
speaking
now.
for myself, unless my lord to kick me under the table, I would prefer to continue with the chronological development of the rule.
Yes, okay, then on we go then in my note. So I've described that the formal rules are introduced on the 30th of March 2019, and then what happens is that, of course, in the period up until the 31st of December 2020, those two definitions that I've set out remain substantially the same, although there's a change in relation to the assumed dependency provision for children. So the position before, and this is paragraph 14, the position before the changes made by HC 813 is as set out in paragraph 14, and what we've done there is just underline the changes since the 30th of March 2019, and that is the relevant provisions before the changes made by HC 813.
Yeah. Okay.
So we then come to statement of changes HC 813, And could I just ask the court to turn up for simplicity the explanatory memorandum?
Yes,
It's at tab 26
in the authorities bundle.
in the authorities bundle.
Just sort of like here, use the physical page 745 HC 813, or is it an explanatory memorandum?
This is
about
it's an explanatory memorandum about HC 813.
I still haven't ever seen H13.
No, that was simply not to give the court unnecessary paper, because the rules as amended by HC 813 are the rules that the court has in tabs 8 and 9 of the authorities bundle. But of course, if the court would like HC 813, I can provide that, or at least
It doesn't say anything.
Well, it presumably includes the words that we now.
Exactly.
That's
Yes.
all, yeah.
Yes. So that's why we didn't provide that. But this explains what it did. So the relevant section begins on page 746. At 7.52 there's an introductory section, but I'm going to take the court through 7.53. The main changes in respect of the EU settlement scheme and the EU settlement scheme family permit are as follows. So the first bullet, to provide access to the EU settlement scheme for a resident EEA or Swiss citizens' existing close family members who are resident overseas at the end of the transition period, or who've been resident in the UK before that point and subsequently break the required continuity of that residence, where the family relationship continues to exist when the family member seeks to join them in the UK. So this is for the first time introducing rules to cater for that situation.
Hang on one second. And this is because the IP day is becoming imminent,
It is, yes.
and the government wished, and I think was required by the withdrawal agreement, to make provision for joining family members
Yes.
After withdrawal.
Yes, and if I'd shown the court the withdrawal agreement, I would have shown the court Article 10, which refers to join and is dealing with joining family members. So it's a category specifically envisaged by the withdrawal agreement. So the second bullet is separate. So this is simply about the deadline for applications to the EU settlement scheme, and that is the 30th of June 2021.
Yep.
But that is for those resident here, unsurprisingly, because family members who are joining are by definition not here.
Yes,
They not
when I
able to
read
meet
through this,
that.
I put a line through it.
Yes,
so-
so that's that. And then third, your lordships will see, to widen access to the EUSS family permit from the end of the transition period to include, for example, existing close family members resident overseas at that point. So to build on what I said earlier, this is the point from which Appendix EU family permit makes rules for joining family members. That's what this explanatory memorandum is explaining.
Does that mean that paragraph FP6, as we now have it, was new or just redrafted?
I have to remind myself what SP6 says. Yes, that
I think
that
what
will be new.
I
Yeah.
think what would be useful, just overnight, we do not want the whole of HC 813, which I've seen these things before, will be hundreds of pages. But could we just have the pages which make the changes referenced in these bullets.
Yes.
So that's the one introducing FP6 and the one introducing, well, we haven't got to it yet. EU2A, which we've seen in the bullets, you could just do first. Somewhere here we'll see something introducing EU14A, but we haven't got there yet.
Yes. So those have explained in general. We're now going to make provision for joining family members, and then the third bullet on page 747 says, and this is relevant in this case, to provide that consistent with the agreements in an application to the EU settlement scheme made from the 1st of July 2021, the dependency of a parent or grandparent on the resident EEA or Swiss citizen will not be assumed, but will need to be evidenced where the applicant was resident outside the UK at the end of the transition period. So again, that's joining family members. Now that,
And where they or their spouse do not already have status as a dependent parent.
yes, because that picks up the point that we say that's what provision C, which is an issue in this case, does. That's simply for those people who already have it. So that's the EU settlement scheme, and then similar changes are made for any application made from the 1st of July 2021 for an EU settlement scheme family permit as a dependent parent. So, in other words, you have to show dependency. So how that affects this respondent is this. She makes her application under Appendix EU family permit before the 1st of July, and so she benefits from assumed dependency. But when she makes her application under the EU settlement scheme, because she was resident outside the UK at the end of the transition period, she needs to evidence dependency because that application is made after the 1st of July 2021.
Just to go back to the third bullet point, I'm sorry, I'm being rather slow.
Not at all.
The third bullet point is concerned with applications to the EUSS after the 1st of July,
Yes.
after assumed dependency has been withdrawn. Is that right?
Is that right?
Consistent with the agreements.
Oh,
In an
see, the third,
application,
does my lord mean the third bullet point of all, or the third bullet point
Sorry.
on this page?
no, third bullet point on this page, to
Oh, I
provide that, consistent with the agreements, in an application to the EUSS made from the 1st of July 2021, dependency of the parent will not be assumed, will need to be evidenced, ... where they do not already have status under the EUSS as a dependent parent.
Yes.
Now, how can they have existing status under the EUSS as a dependent parent in an application to the EUSS after the 1st of July?
Because they might already have limited leave, which they obtained as a dependent parent. And yes, that's when that provision will bite.
I see.
And what's the rationale? You've got a system, if you think of it from their point of view, they're abroad, they want to come here, they need to get through the airport to get entry clearance. Having got entry clearance, they then apply for a permit so they can stay with their family. Abroad, they apply for a permit, dependency is assumed, so they leave the foreign country where they're not actually living with the person concerned, come to the United Kingdom. They're 2 or 3 days after the 1st of July when they put in their application for leave to remain. And they say, well, I'm terribly sorry, I know that up until 3 days ago we were assuming you were dependent, but not now. We know you've come here, we know you're living here, but we want to see the proof now.
Well, the question is why did the Secretary of State decide for a short period for joining family members to introduce more generous arrangements than those provided by the withdrawal agreement?
Well,
No, there are 2 questions. why did he give a more generous period? And secondly, having given a more generous period, why does he split it? So that if you've given it for entry clearance purposes, you're still prepared to withdraw it for the next stage in the play.
Because ministers decided, and we've set this out in our response to the Air Centre, because ministers decided that from the 1st of July 2021, those who were not established here before the end of the transition period should show dependency. Now, these rules made clear, we say, that the cut-off was the 1st of July 2021. There was always a dependency requirement, even if it was assumed. The Secretary of State expected that there would be a large number of applications being made in that period to the 1st of July, as indeed proved to be the case, because it was the deadline for those making their applications under the EU settlement scheme as well. Now, the way that it works for those who are resident here at the end of the transition period is that their dependency is assumed as at the end of the transition period, which is all that matters for that class. So they have a deadline of the 30th of June. If they miss it, they can make a late application with a reasonable excuse. And that, if they make that application late, what will be relevant for those people who are here at the end of the transition period is that they are assumed to be dependent as at the end of the transition period. It doesn't matter for that class what they were doing later. What the Secretary of State does, if it's a late application, is look back at the date of the transition period. The reason that that class is treated differently in policy terms is because the Secretary of State took the view that those who were already here by the end of the transition period were established. They might have come many years ago and, for example, have been no longer able to show dependency, and that fitted with the generous arrangement that was made that nobody should need to show that they were exercising treaty rights. So that's how it works for people who are here at the end of the transition period. The view was taken by ministers that for those who were coming later, after we had left the EU, after we had ceased to have EU law applicable, that they should, after this brief period, which effectively is an easement simply because of the large number of applications, that they should no longer benefit from assumed dependency. Now, I should say again that although dependency was assumed, it was a proving point. There was still a need to be dependent. Indeed, you've seen in the respondent's letter that she asserted that.
Yeah, but that's a theoretical point. The fact is that you didn't have to prove, you didn't have to be dependent, but you didn't have to prove dependency. So in practice, you didn't have to be dependent. I think my Lord's initial point, that there was a prior point which you identified, was, isn't it unfair that someone who takes the first step, which is the main reason why the FP rules exist, at a time when dependency doesn't have to be proved, when they've made that step and perhaps made all the commitment to come into this country and so forth, then find that the dependency rule has changed for them after they've arrived.
But the rule was the same for them at the time they made the first application, because these changes are made with effect from October 2020.
So your point effectively is that if they'd read the rule carefully and been properly advised, they had about 8 months' notice. It would have been apparent to them that if they were going to make an application, as this lady did a few days before the 1st of July, they'd have to get on the plane pretty quick.
Yes. Because the Secretary of State, and it may often be the case that this court hears arguments about deadlines and how if a person falls on one side of the deadline or the other side of the deadline, that's unfair. But that is the effect of the deadline. The answer perhaps for the Secretary of State would have been, well, don't then give anybody an easement.
Well, no,
but that's that in my submission is the flip side of the coin.
the alternative would be to say, I suppose, that once you have applied for the and received the family permit on a no dependency basis, sorry, it's a shorthand for no need to prove dependency basis, but on a no dependency basis, that would also apply to any subsequent application you make for under Appendix EU.
Yes.
Is there any reason why the Secretary of State shouldn't have done that?
The Secretary of State could have done that, but the Secretary of State made a decision that the easement would be for any application made until the 1st of July 2021 and not thereafter. And the difficulty, if I may say so, of the point that the Air Centre has made and your Lordship's question is I don't have evidence.
No. Well, I was going to say, because my Lord understandably is in all our minds raised this point, I was just exploring it. It doesn't affect the question of construction.
Precisely so, my Lord.
It is effectively a judicial review point.
It is.
On which we introduced for the first time here, and this is really your objection to the, well, I think having had this little digression, which will have given Ms. Knight something to think about, I see your point.
My Lord, yes.
It's effectively a policy decision about how to implement this change is being challenged. On ordinary grounds, it either had to be shown to be irrational or, which is really how the Air Centre put it, discriminatory. And it'd be a question of justification of the difference of treatment.
Yes,
and on which you need evidence, which we haven't got.
Long after these rules were presented to Parliament,
Yes.
which was 22nd of October 2020.
Well, okay, well, let's not argue that point now. What I really wanted to come back to, which is, I think, arguably relevant to construction, just so we can understand, as it were, the history of these rules.
Yes.
Is it clear from the published documents whether the mitigation of the dependency rule, for practical purposes, the abolition of the dependency rule, was always only intended to be temporary and not to exist beyond withdrawal, beyond IP date, or, as it turns out, a 6-month extension of IP date? Or was it simply a change of mind by the legislator or by the Secretary of State as the rule maker about whether it was sensible to go on not having a dependency rule for parents?
I have not asked for and have not seen the various ministerial submissions.
No.
So I can't answer that question. What I can say is in this explanatory memorandum, which is made on the 22nd of October 2020, before these changes take effect, at this point, there isn't a later change. This is the first time that there are joining family member rules. And right at this point that the family member rules are introduced, the Secretary of State is saying, we have decided that this assumed dependency will not apply after the 1st of July 2021. So in that sense, from the outset, from the point that rules are introduced for joining family members, it's being said here that it will stop on the 1st of July 2021. So in that sense, there is no change. If your Lordship's question is, well, what about the fact that that wasn't reflected in the statement of intent, I would need to take instructions. But what I would say...
I don't, because it's not really to do with intent. It's simply to do understanding the policy background, not justifying it, but understanding it. And I'm, unless I'm persuaded otherwise, going to proceed on the basis that we just don't know whether this was always contemplated or was a later development in the Secretary of State's thinking. And therefore...
What I can say, my Lord, is that my instructions on the policy, insofar as I've got them in relation to the Air Centre...
No, sorry to be in use, I didn't quite make my point.
I'm sorry, my Lord.
Policy questions of this sort are an important background to construction when they are published, because then you've got to construe it so far as possible the rules in accordance with the published policy. But if it's not published, then it's a fruitless exercise except for the purpose of a judicial review.
Well, yes, paragraph 7.53 is certainly published. I can check if there was other guidance or anything else published to explain all of this.
Well,
I imagine that there was.
I would assume there isn't. I'm not asking for it. I just wanted to know. We've got lots of material here. I just wanted to understand it.
What I can say is that my instructions in relation relation to the policy and why things were done as they were is in paragraph 11 of our response to the air centre.
Yeah, thank you.
In one sense, it doesn't matter. If you're right on what the rules mean, then harsh though it may be, some may not. I'm not saying it's this case. They may not become dependent. Their husband may not die until the 21st of June. And there won't be time to get a family permit, come to the United Kingdom, and then make an application under the EUSS because you take months to decide them. But you say, that's life. And
Yes,
that's the rules.
yes.
Them's the rules, to quote
And in-
them's the breaks.
Yes, that's right. And in this case, it cuts both ways in the sense that in this case, the Secretary of State did make efforts to get evidence of dependency, and that had been asserted in the first letter. When
Oh, okay, but that's a
Yeah.
different point about the merits. Yeah.
But you say it is the rules ultimately, and if you say there's an explanation logically, subject to coming back to the words of FP2, which made a real problem if there's no apparent purpose to them, you say that is the policy as stated, that's what the rules on your submission mean, and if there is harshness or unfairness, such is life, you say.
yes, and that is the consistent line of authority in relation to the immigration rules, even in a case where somebody's made an application and the rules change
Yeah.
after the date of their application. That's not this case because of what's set out from the very beginning here. The joining family member rules made clear that dependency has to be shown in an application after the 1st of July. So it's not even that. It's not even that
Well,
situation.
they make that abundantly clear in relation to gaining a family permit. I
And
don't think there's any doubt about that. That's what the definition says clearly in relation to Appendix EU family permit. The question we have to decide is whether that also applies in relation to Appendix EU.
yes, although just in terms of the third bullet, it certainly does say in an application to the EUSS, which I've explained is Appendix EU, dependency will need to be evidenced where the
Yes.
applicant was resident.
I thought, I may have misunderstood, I thought if we looked at the relevant definitions as we're eventually going to do in Appendix EUSS, and our fault not yours, we'll find those provisions.
Yes, yes, and that's what I was proposing to do now.
Well, let's do it.
So that is the explanatory memorandum. I'm going to start with Appendix EU-FP, which is at tab 8 of the authorities bundle. I see the time. I have not made the progress I hope to make.
Well, no, you don't blame yourself. I mean, once we have done this, the submissions will be very short.
They will, yes, they will. So this is the application that was granted on the 15th of November 2021. This is Appendix EU-FP. And I need to turn my back. I won't do it now, but your lordships have asked me why does it refer to for the purpose of acquiring leave to enter in FP2. My central submission on FP1 in terms of purpose, and it reflects the overall intentions of the scheme. I'd ask the court to start with paragraph 1 of FP1, which is clear. This appendix, not another appendix, but this appendix sets out the basis on which a person will, if they apply under it, be granted an entry clearance. So that is the purpose of this. FP2 can't be read in isolation. It has to be read with FP1. This sets out the basis on which a person will be granted an entry clearance, and A is the provision that's relevant here, in the form of an EU settlement scheme family permit. To join a relevant EEA citizen, that's relevant here in the UK, or to accompany them to the UK. So that's its purpose. It's all about the grant of entry clearance. Appendix EU, as we will see, has a different function. So the fact that it has effect in connection with the granting of entry clearance, C1, for the purpose of acquiring leave to enter or remain in the UK, does not mean that this appendix is giving somebody leave to enter or remain under Appendix EU, because it has effect in connection with the granting of entry clearance, C1, that's what it's about, and that is for the purpose of acquiring leave to enter or remain by virtue of Appendix EU, which is a different appendix. So
Well, we've got that, but your problem is FP2, which appears to detract from that.
but it doesn't in my submission, because what it says is it has effect in connection with the granting of entry clearance.
Yeah, that's
but
good.
That's
That's consistent.
CFP1.
And an entry clearance, of course, we know from section 33 is not leave to enter.
No,
It's evidence of eligibility
It's-
of leave to enter.
and it's exactly. And what I haven't done, because and your lordship quite rightly reminds me, I haven't shown the court. I haven't shown the court, and it was earlier in my speaking though. I haven't shown the court the order, which is at tab 6 of the authorities bundle. We can go to it in a moment if we may, when we've looked at these rules. But that makes clear that by operation of law, the entry clearance is converted into leave to enter or remain. It's nothing to do with any appendix, because the appendices are the immigration rules.
Yeah,
It happens by operation of law. So
Speaking
may-
for myself, we've got that point. I
Yes.
agree. You've got to show us it, but can we just go back to FP2
Yes.
for entry clearance for the purposes of acquiring
Leave to enter.
leave to enter?
By virtue of
If it said leave to remain in the UK,
Yeah.
that would be completely consistent with your submissions. It's the phrase
yes.
leave
So-
to enter.
So what the court is saying is, well, that must mean, or at least supports the point that it's the leave to enter is not by operation of law, but rather it is under Appendix EU because of those words.
Yes.
Yes.
Well, we're not saying it. We're
No,
just
it's the
trying to
point
work
that-
out what it means.
Trying to give
Yes,
some
it's-
meaning.
Yes, no, indeed. It's the point that your lordships are putting to me. I need that there will, or at least maybe, because this is highly complicated, be an explanation as to why those words are there. But I do need to ask, and I may.
Well, I
need to
think
do that
we're going to have to part. I hope we'll nearly finish this afternoon. We obviously won't finish. So I think you better give us your
Yes.
defined position on this first thing tomorrow morning.
Yes, I will do. So carrying on through then, FP2.
Just before we start with FP1, do we get anything relevant at all out of the reference to the EU settlement scheme travel permit, or can we just ignore that?
No, I don't think. I don't
No
think
idea
the
what it
lordships need to
is,
be
but
troubled
we
with
don't
that.
need to know. Okay.
No. So then FP3, again, several references to this appendix. That's about validity.
Yeah.
FP6 is eligibility, which is the provision at issue in this case, which and the applicant was eligible, it was granted, and then a reference to under this appendix again. But the courts know, as this application was granted, I perhaps don't need to spend any time on it. The definitions which are relevant for an Appendix FP application for this applicant are as follows. Family member of a relevant EEA
Well, as you
citizen.
say, you don't need to spend any time on it because it was granted.
It was granted. Can I just give the court the page
Okay.
numbers, perhaps, or would the court prefer that I
All
skip
right.
that?
Okay.
So there are three definitions. Page 158, family member of a relevant EEA citizen. Page 150, the definition of dependent parent, and page 170.
So
This is all by way of defining what's meant by B.
Yes.
Yeah.
And then page 170 is required evidence of family relationship.
okay.
And then,
And that, sorry to interrupt, but that's where one has set out clearly in those definitions that dependency is only assumed up until the end of the 6
Yes.
month period.
because
So that it's clear from those definitions that if you don't apply for your family permit
yes,
within the 6 month grace period, you've got to show dependency.
yes, and this applicant did benefit from the assumed dependency provision, so wasn't troubled by that. But yes, your lordship's quite right. For anyone who was applying after the 1st of July 2021, they would need to have shown their dependency before they were granted a family permit. So I can turn to Appendix EU, which is the rules for the EU settlement scheme.
And you might want to point out to support your submission that is the entry clearance under either Rule 25A, which you have referred to, or the order, is FP11, which talks about Annex 3 applies in respect to the revocation of an entry clearance that is granted under this appendix.
Yes.
And cancellation given leave to enter granted by virtue of having arrived in the UK with an entry clearance that was granted under this appendix. And you will say, I imagine, that's all of the piece.
Exactly, because there are repeated references in this appendix to this appendix.
And also the entry clearance granted, the leave granted by virtue of having got an entry clearance under the appendix.
Yes.
The leave to enter follows from
Yes.
the entry clearance, not from some other legal event under the EU, is what I assume
Yes.
you're going to submit in a minute.
Yes, your lordship makes a very important point, because that precisely reflects what we've submitted about the leave to enter or remain order, because it refers to the cancellation and curtailment of leave to enter granted by virtue of having arrived in the UK with an entry clearance that was granted under this appendix. So exactly that the leave to enter is granted by virtue of having that entry clearance, but it's granted by operation of law. It's nothing to do with Appendix EU.
Yeah.
Despite FP2, but FP2 is a broad purposive clause, which is saying subject to the words leave to enter, is a broad purposive clause saying, well, you know, that will get you here to make your application. So turning then, it's 4:15.
No, keep going.
Appendix.
Sorry, but do we? I think you draw attention in your written argument also to the fact that this will be an entry clearance converted into leave to enter for only 6 months, or the remaining period of 6
Yes.
months, compared with a potential 5-year
Yes.
leave to enter under Appendix EU.
And in fact, yes, my lord, I'm very grateful. Given the time, actually, it may be more sensible if I turn first, and I missed it when I went to HC 813. If we could go to tab 6, the authority bundle, and look at the immigration leave to enter and remain order.
Yeah.
Because in time, it flows after the grant of entry clearance. So, tab 6, page 92, article 2.
Yeah.
An entry clearance which complies with the requirements of Article 3 shall have effect as leave to enter the UK to the extent specified in Article 4, but subject to the conditions referred to in Article 5. So the requirements are set out in Article 3(1), and they simply say it shall have effect as leave to enter if it complies with the requirements of this article. And then at 3, either it's endorsed with the conditions to which it's subject, or it has effect as indefinite leave to enter the UK. And then the key.
And was it in this case?
Well, there were in fact. It wasn't indefinite leave to enter, but there were in fact no specific conditions. If one looks at the. One looks at the, just turn back.
Tab 3, isn't it?
Tab 3, yes.
Yes, I see. But that's fine.
Yes,
only
it doesn't-
that just means it's subject to no conditions.
Yes,
Yeah.
that,
Yeah. Okay,
yes, there were no
fine.
specific, other than it's not,
Yeah,
it's
but the
limited.
purpose is
It's
specified
entry
under
clearance,
3(2).
yes.
Yeah.
So the key provision is Article 4(3).
Yeah.
Page 96. In the case of any form of entry clearance to which this paragraph applies, and just pausing there, if the court looks at 3AC on the next page, 97, paragraph 3 applies to any other form of entry clearance. So that's what covers this case.
Yeah.
Just to confirm that 4(3) applies. And then going back to 4(3), it shall have effect as leave to enter the UK on one occasion during its period of validity, and on arrival in the UK, the holder shall be treated for the purposes of the Immigration Act as having been granted before arrival leave to enter the UK, And what's the period? In the case of an entry clearance which is endorsed with conditions, there is a condition in a sense, it's the time condition.
Yes,
on
I
it.
see.
And I showed the court it was May 2022. So in the case of an entry clearance which is endorsed with conditions for a limited period, being the period beginning on the date on which the holder arrived in the UK and ending on the date of expiry of the entry clearance. So her leave to enter expired on the 21st of May 2022.
The only oddity is it's said to be multiple entries.
Yes, I remember.
And then this talks about entry on one
Yes.
occasion.
Yes, I remember your lordship's question, and I need to check
Think
that.
about
because
that.
It's quite
But
technical.
25A may not have that of the immigration rules, which you don't seem at all attracted by. It says the same about leave to enter, and all that ties it to is Article 3, I think, of the immigration order. So by one route or another, you say it's clear that the effect of arriving with an entry clearance document is that leave to enter as night follows day, but not as night follows under the EU.
No.
I think, since my lord has understandably referred you to the provisions of the immigration rules to the same effect, I think, can we have those tomorrow? It's
Yes.
it is Rule 25A.
Yeah, I think
Yes.
so.
Yes. I've been
I think
passed
those
a
are
note
the
that I
only
need to
ones.
read.
Well, there's about four. Well, there's a definition in the Act, which I don't think we have, about what entry clearance is. And then there's Rules 24 to onwards, 25A, deals with entry clearance.
Yes, well, if we can have tomorrow morning or indeed overnight, but certainly tomorrow morning, the provisions in the statute and the rules relating to entry clearance and leave to enter, that will, nothing probably turns on them, but we want to, in any judgment, set out the correct firm ground beneath our feet.
Yes, absolutely.
Okay, well, now you've ticked that box, therefore taken us to the 2000 order. Is this a good place, or would you rather, I'm very happy for you to finish off any related submissions.
No, I think if the court is content, that is a good place to stop, because I will then get into the meat of Appendix EU tomorrow, and then my submission will be quite brief thereafter.
Right, we'll then hear from Mr. Metzer and from you in reply, and then we'll deal with the with the intervention.
Could I make a point in relation to a point your lordship raised at the outset about why did the Secretary of State not raise this point earlier? I think from the Secretary of State
Which point earlier?
that the Air Centre's argument was outside the scope of the appeal. It was on reading the Air Centre's submissions on the 4th of March, to which we were directed to respond by the 27th of March, that we were then alive to what was being argued.
But weren't those submissions part of the initial application?
No.
I thought
There was a letter, but there weren't the submissions.
Well, let's just bottom that out now, so that there's no misunderstanding. And that's what puzzled me. And if what you say is right, then it's a complete answer. But we actually have, don't we? Having defined all the bundle, there's a separate bundle which I've got for.
So it's bundle 3, page 15. Mr. Narley's very helpfully told me it's the letter of the 19th of February, paragraph 6.2.
Ah, wait a moment, I may have misunderstood.
So perhaps it's
Yes, I see, but I had thought that also perhaps let me just explain what I think the position is. You tell me if I got it right or wrong. In the correspondence which preceded the making of the application, you only saw effectively what appears in Huddleston's letter.
yes.
You didn't see the draft submissions themselves.
No, not until the 4th of March.
It was only those draft submissions were then included as they had to be with the application notice.
I think I'd have to ask my learned friend to answer that. Yes, I'm being
They
told that's
were,
right, because the application...
But I see, yes. So at the time you said we have no objection, and that was referred to in the application notice. you hadn't seen what you were being asked to,
Yes,
you
because
hadn't been
that-
able to see the details of the
I should,
submissions.
I should say, out of fairness to my learned friend, paragraph 6.2 says the Air Centre will consider the material provisions of Appendix EU. Well, we know that they haven't done that, but they do say, and the withdrawal agreement, including the requirement to construe any provisions which implement EU law in line with general principles of EU law. In particular, submissions will focus on the general principle of equal treatment. But I certainly hadn't been able to work out from that we were going to get what we did.
Yes, I see.
And
Well, at the end of the day, it's perhaps unhelpful for me to make. I was puzzled, but I now begin to see whether or not you should have spotted what was coming and objected at that stage. Can't mean that you, once you've seen the developed submissions, you aren't entitled to say that they're not open to us to decide or wouldn't be appropriate for us to
no,
decide.
and I think it's right to say that the Secretary of State rightly has been keen not to stand in the way of people intervening
No,
in
well,
various cases.
That's a very fair point as well.
And that the submissions that we get often develop, and the written submissions are not
Yeah.
always, and so.
Well, it's water under the bridge. Yeah, but
that's where we
thank
are.
you. Perhaps we often get helpful interventions from the Air Centre. So this
Yes.
is right now.
I would wonder if I might, if it's possible, just to rehearse that point, which is that we did identify in paragraph 6 of the application letter, and we have addressed. The focus of our submissions is about the relevance of the withdrawal agreement and addressing directly the Secretary of State's case. That it's.
Well, I think you're trying to make submissions which you're going to have to make later. So, thank you. Very well. 10:30 tomorrow.
All right.